Bill Isaly, the first assistant U.S. attorney in Los Angeles. He's telling 20 million people that exercising their Second Amendment right near a police officer is highly likely justification for you to be killed. Here's the problem. He's dead wrong. In fact, his statement is so legally dangerous that even the NRA and Gun Owners of America, groups that usually back law enforcement to the hilt, are calling his words dangerous and wrong. Today, we're going to look at the real law, why mere possession is not a death sentence, and the one Supreme Court case that every gun owner needs to know before they ever step foot in public. First, let's give this some context. Bill Isaly isn't just a lawyer, he's the top federal prosecutor for the Central District of California. This tweet came out right after the recent shooting of Alex Pretty in Minneapolis, a case where a legal gun owner was by federal agents while allegedly holding a smartphone, not even a weapon. When a man in his position says, "You're likely to be shot and it's legal," people listen. But the law doesn't care about a prosecutor's opinion on Twitter. The law cares about objective reasonableness. Every legal gun owner in the United States needs to know the case Graham v. Connor. This is the 1989 Supreme Court case that sets the rule book for every police shooting in America. Court was clear. We don't judge an officer's action with 20/20 hindsight. We judge them based on what a reasonable officer on the scene would do. But here's the part Isaly missed. The presence of a gun is not a blank check. The Graham factors require a balancing act. The severity of the crime. Are you a mass shooter or are you just walking to your car? Number two, the immediate threat. This is the big one. Possession of a tool is not a threat. Behavior is a threat. Number three, resisting or fleeing. Are you actually fighting or just standing there? If you're lawfully carrying, whether it's open or concealed, you haven't met any of those factors yet. So let's go through some scenarios. Let's put Isaly's theory to the test. He said if you approach while armed, the officers are highly likely justified in shooting you. Let's look at these three scenarios. Scenario A, the good citizen. You're open carrying a holstered sidearm. You see an officer struggling with a flat tire, and you walk over to ask if they need help. You aren't reaching for your gun, and your hands are visible. Is it highly likely they can shoot you? No. A reasonable officer knows that millions of Americans carry guns every single day. Approaching is not an imminent threat. Scenario B, protester. You're at a rally. You're angry. You're yelling at the police about your rights. You have a rifle slung over your shoulder. Is it highly likely they can shoot you? Still no. The Supreme Court has ruled that being annoying or angry is not a justification for lethal force. Unless that rifle comes off your shoulder and points at a human being, there is no imminent danger of death. Scenario C, the Isaly special, the only time he's right. You approach an officer while holding a gun in your hand, ignoring commands to drop it, and moving in a low ready position. Now Isaly's right, because you've checked the box for immediate threat. Do you see the difference? Isaly's tweet treats scenario A and scenario C exactly the same. And that's why it's so legally illiterate. The real danger of this prosecutor's logic is it tries to turn a constitutional right into a de facto threat. If we accept that approaching while armed justifies a shooting, then the Second Amendment effectively ends the moment a police officer enters the room. We cannot have a country where mere possession of a legal item establishes imminent threat. If you're a legal gun owner, you aren't a would-be assassin just because you're nearby. You are a citizen exercising a right. So, if you see this tweet going around, remember, law enforcement officers are governed by the Constitution, not by the Twitter feed of a prosecutor in California. The standard is necessity. Deadly force is only legal when it is necessary to prevent imminent death, not just because an officer felt uncomfortable because you had a holster on your belt. Know your rights. Keep your hands visible. And if you are carrying, be the most polite person in the room, not because the law says you have to, but because it keeps you alive while we fight these battles in court. If you found this breakdown helpful, hit that subscribe button, like this video, leave me a comment. I don't even care what the comment is. If you're facing illegal troubles in Indiana, give us a call here at the Marc Lopez Law Firm, 317-632-3642. We'd love to talk to you about your options. Most importantly, be safe and always plead the fifth.